Pamela Peel versus Nancy Gerler.
This case opens with tension already simmering beneath the surface. Two parties, Pamela Peel and the former tenant, Nancy, are about to clash in front of Judge Simpson, and the stakes are far higher than a simple rent dispute. We're dealing with months of unpaid rent, conflicting stories about rental assistance, illness, evictions, phone calls that never got returned, and a tenant who believes she shouldn't be responsible for the full amount. Meanwhile, the landlord insists she's owed over $12,000. But here's the twist. Nancy isn't just defending herself. She's building a narrative filled with chronic illness, multiple assistance programs, and a belief that the landlord intentionally refused help so she would move out. This is exactly the kind of case where small details become huge turning points. Did the landlord really refuse agency help? Did the tenant reasonably rely on assistance programs that ultimately couldn't pay? And which version will Judge Simpson believe once emotions peak later in the hearing? Stay locked in, because this case builds layer by layer, and every moment adds weight to the final confrontation where Judge Simpson must decide whether this massive debt stands or whether Nancy successfully undermines it.
Yes, Your Honor, I'm here on Zoom.
Okay,
Your Honor, this is Nancy. Your Honor, Nancy Gerler, appearing on phone Zoom.
Yeah, I will read it for just a moment.
Oh. All right, and where are we on this case?
Your Honor, good morning. I am requesting a money judgment from the court for a total of $12,238. This amount includes unpaid rent of $12,950, court costs of $215.
Say that again. How much is the unpaid rent?
The moment Judge Simpson asks this question, you can feel him shifting into calculation mode. Judges who oversee landlord-tenant disputes deal with numbers constantly, and accuracy matters. Pamela responds confidently with the total $12,950 in unpaid rent. For many viewers, this number alone raises eyebrows. How does unpaid rent climb that high before an eviction or a payment plan kicks in? This is a critical legal moment because rent totals form the backbone of any money judgment. Judge Simpson isn't just verifying figures, he's assessing credibility. When a landlord presents numbers this large, the court needs clear documentation. And notice the slight stumble from Pamela earlier about returning the security deposit, then clarifying she is actually applying it toward rent. That might seem small, but inconsistencies invite closer scrutiny. Here's a question for you. If someone owed you nearly $13,000, would you have allowed them to stay this long, or would you have pursued legal action earlier? Cases like this force judges to untangle financial responsibility while navigating emotional narratives. This is just the first crack in the story. Bigger clashes are coming.
The unpaid rent is $12,950. The court costs are $215, and the service fee was $68. And I'm refunding the security deposit in full, even though the apartment was not clean to the degree that. Yeah.
Anyway. How much was the security deposit?
What?
How much was the security deposit?
It was $995.
Okay, so let me answer this question.
Yes.
If you're requesting a money judgment and there's rent owed, why are you returning the security deposit?
Oh, no, I don't. I'm deducting it from the rent owed. And the balance, the balance owing is $12,238.
I see.
Does that make sense?
Well, $12,238 is something after you deducted the security deposit out. She's no longer in the unit.
Right. She moved out on February 2nd at midnight.
This timestamp marks a turning point. Possession has ended. Once a tenant vacates a unit, the legal landscape shifts dramatically. The case is no longer about eviction or regaining control of the property. It's strictly about money owed. Judge Simpson recognizes this instantly, which is why he questions the math in the security deposit handling early on. But here's where things get more interesting. Tenants who vacate often assume leaving removes financial responsibility. In reality, rent owed up to the move-out date still applies, and damages or unpaid amounts don't disappear once the keys are gone. When Pamela states the exact date and time Nancy vacated, she's anchoring the financial timeline. Here's the engagement question. Do you think moving out should reduce a tenant's responsibility for previously owed rent, or should those debts remain regardless of circumstance? And keep watching, because the tenant's explanation, rooted in illness, agency issues, and alleged communication problems, is about to collide directly with the judge's legal framework.
All right, Ms. Gerler, what do you have to say about that?
Your Honor, number one, there was no inventory taken upon move-in. Therefore, she has no claim against the security deposit, which should
That's
be
not,
applied.
ma'am, let me stop you there. That's not true. Because under the Security Deposit Act, if there's rent that's due and owed, she could take the security deposit for past due rent.
Oh, absolutely, and I volunteered that in court December 20th. I told her she could keep that rent for
She's done.
January's, the damage deposit
About the
for
rest of the,
January's rent.
so what do you have to say about the rest of the monies owed?
Your Honor, I have presented to you previously. I have been subject to chronic illness, and there are now 4 separate occasions where Ms. Peel was not cooperating with myself or agencies to assure monies for her. As I mentioned previously, Faith in Action had offered her monies that she refused. I knew that we could be brought current up to the $3,000, almost $3,000 owed at that time in July of 2022 when she declined to take the money. My conclusion was she wanted me to move, and Ms. Biles at Faith in Action said that the $2,000 allocation I could then use to help me move, put down security, and first month's rent. I proceeded to attempt to move, started organizing and getting rid of things, getting things out of storage, and got sick again with COVID in August of 2022. I was served another notice to quit December 2nd, 2022. After I had spent all of November emptying my storage units to get to the large furniture items, I told them I would sell, give them monies, which I proceeded to do
Ms. Gerler.
in December.
Ms. Gerler.
I'm telling you. Oh, okay.
And you don't want to yell at me.
I didn't mean to, sir. I'm sorry. I also have post-traumatic stress disorder, if you'll recall.
Okay, that's fine, but you do not need to yell at me. I am trying to stop you because what you're telling me seems to me to be irrelevant. That would be relevant to the issue of possession. You've given up possession of the unit.
This is one of the most emotionally charged moments in the hearing. Nancy begins recounting health struggles, illness, storage issues, attempts to sell belongings, details deeply connected to her personal hardship, but not necessarily to the legal question. Does she owe the rent? Judge Simpson steps in firmly, not to dismiss her experiences, but to redirect the hearing back to the legal issue. His tone is calm but authoritative. He acknowledges her PTSD and health concerns while making it clear that context is not a legal defense to unpaid rent once a tenant has already vacated. This is a classic courtroom moment. A tenant argues from emotion, a landlord argues from numbers, and the judge must steer the case back to the statutory path. Engagement question. Do you think Nancy's personal hardships should reduce the financial judgment, or should the court strictly follow the math regardless of circumstance? This clash sets the stage for the judge's ultimate decision, to escalate this to a full trial.
I have given up possession of the unit.
She is asking for a money judgment.
Exactly, sir. So, I have attempted to pay her money and do whatever I to pay her money all the way along. In January of 2023, she asked me, could I pay at least $500 a month, which I did consistently.
Ma'am, are you saying you do not owe this money?
I'm saying that any help I tried to get from any agency to pay her, including Hawk, after our last court date, I had an appointment with Hawk on December 18th. I believed that Hawk was still out there to help me with this money judgment. And I checked back in with Hawk.
Ma'am, they won't help with the money judgment. They will help you maintain your tenancy by paying if you're going to remain in the unit. But you're out of the unit now.
Sir, Ms. Peel did not return the calls on December 19th or January 3rd from Hawk reaching out to her to try to assist with this situation. They closed the case. There might have been help from them and their affiliated agencies, but there are 4 occasions when I attempted to get help from other agencies, including the Department of Health and Human Services, when the situation where fraud might have been done in the name of another tenant wasn't cleared up for me either. So no, I do not feel that I owe the full judgment here.
This is Nancy's clearest, most direct statement of her defense. Not that she owes nothing, but that she doesn't owe the full amount. In legal terms, she is disputing the calculation, not denying the debt entirely. But here's the issue. Her argument relies heavily on agency assistance programs that help tenants only if they remain in the unit. Judge Simpson explains this multiple times. Once a tenant leaves, most Michigan rental assistance programs refuse to pay past debts. Their purpose is preventing homelessness, not clearing arrears after the fact. Nancy insists the landlord failed to return agency calls, another serious allegation, but without documentation, it becomes a he said, she said situation. For a judge, that's not enough to offset a calculated rent total. Here's a key question for you. Do you think the landlord had a responsibility to cooperate with agencies even if she believed the tenant was leaving anyway? This disagreement is big enough that Judge Simpson decides only a formal trial, with evidence, can resolve it.
I have done
all right, that's fine.
I could.
Ma'am, that's fine. So here's what I'm going to do. I'm going to set this for trial. Both of you need to appear in person, and I'll just have a trial. You guys need to bring all your paperwork, because what you're explaining to me, ma'am, would be rental assistance if you were going to stay in the unit. You're no longer in the unit, but you feel that you don't owe the money. If you don't owe the money, then that's got to be hashed out, and we're going to have a trial.
Your Honor, I do not feel that I owe the full amount, and feel we must go to trial to do this.
That's the way we do it. It's a court. So we have a trial.
I am very sorry to see things go this way, Your Honor. I have done the best I can under my limited circumstances.
You don't have to be sorry about it. It's what I do every day. So.
All right, Your Honor.
So we'll have a trial. Emily? Abby, when can we have a trial?
Okay,
Hold on. I'm just trying to get a trial date. Just hold on. As soon as she decides to give me one, we'll get it. Emily?
March 7th at 9 a.m.
I'll set your non-jury trial, March 27th, 2024, 9 a.m. That is in person at the courthouse.
Your Honor, you do realize that I have great difficulty being in Wi-Fi and all of the.
You have great difficulty in what?
In being in your courtroom because of all of the electromagnetic frequencies in your vicinity as well as the courtroom. That's why I'm on phone Zoom every time. I'm
Ma'am,
suffered
I'm setting
physical.
it in, ma'am. I'm setting it in person. If you send me something medically that may make me change my mind, then I may let you appear via Zoom, but I'd have to have something from a doctor that the court can check out. Otherwise, I will expect both parties in person.
Yes, Your Honor, I will present to you that evidence, and I appreciate your consideration. And
I'm making it
Sir, sir.
right now that this is set for non-jury trial in person.
All right, and sir, I just want to let you know I was not yelling at you. My microphone was all the way turned up, and I.
Ma'am, it's okay. If you were yelling at me, I just tell you don't do it. I get what you're saying. That's fine. I've been yelled at by a lot of people. Doesn't bother me. Thank you.
Sir, you do not deserve it. Thank you. Goodbye.
You're right. I don't deserve it. Thank you. So that's right. All right. Who said that? Alan. You need to calm down. Say too much.
Can we call the Wayne Green?
This hearing ends with Judge Simpson doing exactly what a judge does when facts are disputed and emotions are high. He sets the matter for trial. Both sides claim the other prevented payment assistance. Both disagree on communication. Both present different narratives about responsibility. What makes this case important is how it highlights the intersection between law and lived experience. Legally, unpaid rent is unpaid rent. Emotionally, Nancy feels she tried everything and was blocked by circumstances and health struggles. Pamela believes she followed the law properly, applied the security deposit correctly, and is owed the remaining balance. In the upcoming trial, documentation will be decisive. Payment histories, agency call logs, notice timelines, medical accommodation requests, and written communications. Once those are presented, Judge Simpson will be able to determine whether Nancy owes the full $12,238 or whether some portion should be reduced. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.